Welcome to the Common Bridge, where policy and current events are discussed in a fiercely nonpartisan manner. The host, Richard Helppie, is a philanthropist, entrepreneur, and political analyst who has over 1 million listeners around the world. The Common Bridge is available on Substack.com and draws guests and audiences across the political spectrum.
Hello, this is Rich Helppie. I'm your host of The Common Bridge. Today we're going to talk about insurance, and we've got an expert with us today, Mr. George Silas. Now, this might be a little specific toward Michigan, but could have implications in other states. Let me tell you a little bit about what's going on. In May of 2019, the Senate Republicans in Michigan, presumably under pressure from the insurance industry, introduced Senate Bill 1 to provide meaningful rate relief to drivers. Okay? Sounds pretty good, right? A year later, the House passed their version with House Bill 4397, despite threats from Governor Gretchen Whitmer that she would veto the bill. Now, why would the governor not want her constituents to benefit from this and then change her mind? Well, now here we are 2 years after the passing of the bill, and all of a sudden Michigan is in a sudden hotbed of controversy that the full catastrophic benefits are no longer available that they were prior to the reform. I'm going to do that again, Brian. Fast forward almost 2 years after the passing of the bill, and Michigan is all of a sudden a hotbed of controversy now that the full effect of the bill are being felt by Michigan's insured and, tragically, by the unfortunate victims of catastrophic car accidents both prior to and after the reform. What are the issues? Do they have national consequences? Do other states have similar laws, or are they considering them? And of course, with us today to help us understand both the law and the current issues, George Silas of the Sinas Dramas law firm of Lansing, Michigan. Mr. Sinas, thank you so much for joining us on
It's
the
my
Common.
pleasure to be here. Thank you.
So, our guest, our audience likes to know a little bit about our guests. So, do you mind telling us a little bit about yourself? Where did you spend your early days? What's been your academic preparation, and maybe a little thumbnail of your professional work?
Sure. I grew up in Lansing, Michigan. I went to the University of Michigan undergrad, and I went to law school at Wayne State. I came back to Lansing right after my law school days, and I joined a law firm that my father started 70 years ago.
Oh,
And,
right.
and I've been with that law firm ever since I got out of law school. And I'm pleased and proud to say that my two sons also went to law school, and they joined the law firm about a decade ago and are doing essentially the same kind of work that I'm doing, specializing in the auto no-fault area. And they have gone on to begin very impressive careers.
Well, that's fantastic. I love hearing about multi-generational businesses, and it's a pleasure to be able to work with your sons, I would imagine.
It
Uh,
sure is.
what exactly is the scope of practice? And do you work on the defense side or the plaintiff side? And if there is such a thing, what's a typical case that your firm might handle?
We work exclusively representing seriously injured people, primarily injured in motor vehicular accidents, semi-truck accidents, motorcycle accidents, regular automobile accidents, etc. We also do other types of personal injury work, such as premises liability and certain other injury-producing situations. But the vast majority of what we do is in the auto area. And the no fault law actually went into effect in 1973, which was right before I got out of law school. And when I passed the bar, there was absolutely no case law interpreting this new statute. So, guys in my situation were starting at ground zero of auto no fault. And over the last 40 years, this system, which was brand new in 1973, has gone on to become one of the fastest growing areas of jurisprudence in recent Michigan history.
And if I understand this correctly, prior to the advent of no fault, if there was a car accident, that there would be some kind of court hearing to determine who was at fault in the accident, and therefore that at fault person would carry the liability for the damage to the vehicles and medical care and the like. Is that
That's
correct?
that's essentially correct. And what you just described is a tort system. And the
Hmm.
vast majority of the United States is on a tort system. And that means that the victim, the guy that gets hurt, can only recover medical expenses if the other guy caused the accident, if the other guy was at fault. If the victim caused the accident, or there was no intervening person that caused it, such as a deer running out in the middle of the road or hitting black ice and smashing into a tree. In those situations where there was no at fault driver causing the event, the victim had no recourse. And the only way they were going to get their medical expenses paid is if they had health insurance. And if they didn't have health insurance, God help them. They really would be without the ability, financial, to secure the necessary treatment. So the no fault law went into effect, and it wanted to correct that. It wanted to make sure that we created a reparation system where every victim, regardless of who caused the accident, would have certain guaranteed medical expense benefits and wage loss benefits so that they wouldn't have to depend upon the fortuities of a tort based system. And at the time Michigan passed its law, I believe that there were approximately 16 states that had no fault. That list has dwindled. I believe we're now down to 12 or 14. So no states have joined the no fault ranks. It is very important when you're talking about Michigan no fault to appreciate the fact that Michigan's system was by far the most comprehensive of any of the other 13 states that had some version of no fault. In Michigan, we did what nobody else in the country did, and that is this: we adopted a system that provided guaranteed lifetime medical and rehabilitation expenses. That is what was in everybody's auto policy, lifetime coverage.
So,
And we were able to do that without spending a penny of tax dollars or government funding. It was all funded by ourselves through our auto insurance policies.
so, I mean, that to me sounds like the essence of insurance. Everybody puts in a little bit for the few that might need to get a payout at some day. And I know there are many cases. You know, the classic is a 17-year-old that gets T-boned or loses control of a car and hits a tree and becomes a quadriplegic and needs lifetime care. And capping those benefits would be very, very cruel. We had hockey players of Vladimir Konstantinov injured and permanently disabled in a car accident, um, and they were getting great care. Why did that needed to be changed?
Well, the problem was the premiums. They kept going up and up and up, and there's a whole lot of reasons for that, and we could talk for days. But the premium kept going up and up and up, and politically, this became a real hot potato. And over the last 20 years, there were a number of proposals made to change no fault. And two of them involved ballot propositions, 1992, 1994, where legislation similar to the legislation that was just passed was resoundingly defeated by Michigan voters at the poll by margins of 60 to 40. And,
Wow.
and the Michigan voters didn't want to lose their lifetime medical. But nevertheless, the premiums kept going up and up and up. And the mayor of Detroit got very much involved in this. There were a ton of uninsured drivers in the Detroit area and other metropolitan areas around the state. And that created the problem that you just identified. If you have fewer people paying into the system, then that means the rest of us that are in the system paying and have to pay more to make up for the folks that can't afford to be in it and pay. And so, long story short, the premium drove the policy. And that's unfortunate when that happens. The premium drove the policy, and The first thing that they did with this new law is they took away the guaranteed lifetime medical. Now you had to buy it. Your policy no longer automatically contained it. Rather, you had choices. You could buy lifetime medical. You could buy $500,000 of medical expense. You could buy $250,000. If you were Medicaid eligible, you could buy as low as $50,000. And the unfortunate thing is that folks who don't have the economic wherewithal ended up having to choose something less than the lifetime medical. And then, God forbid, if there's a catastrophic accident like the one you just described, where a young kid becomes a quadriplegic, there's just not enough coverage there. There's not enough coverage, and there's a wasted life.
Thank you for listening or watching this segment of Richard Helppie's The Common Bridge. On Substack, you can access the full archive and bonus columns, podcasts, and interviews for only $5 a month. At substack.com, search for The Common Bridge and subscribe.